Hello, I'm Jaspreet on this side, and this is the seventh video on summary and purpose is revision of Companies Act 2013. We are using Saransh by Institute of Chartered Accountants of India (ICAI). I am company secretary by profession, and my name is Jaspreet. So let's proceed further. So far, in the last video, we covered kinds of share capital, voting rights, sweat equity shares, personation of shareholder. These were covered in previous sixth video. This is the seventh video, and we are starting with alteration of share capital. Section 61 to 70 provides for alteration of share capital. I'm using this because I like the graphical design of this book, and disclaimer is that this is only for knowledge and revision purpose. I am refreshing my memory, and so can you. Thank you. So now alteration of share capital. Now why do we require to change or alter our share capital? Let's take from top. Bonus issue. If the company is issuing shares and bonus shares are issued under section 63, bonus shares are issued without any consideration to the existing shareholders, so then share capital will get altered on the issue of bonus shares, provided company has power under its articles of association. Then rights issue under section 62 of the Companies Act 2013, rights issue. So rights issue also will alter share capital. Rights issues are also offered to the present shareholders of the company, and they have right to subscribe, means here they pay for the shares, or they have right to renounce their right in favor of some other person. So rights issue will also alter the share capital. Then power of limited companies, section 63. Section 61 provides that limited companies have power to alter their share capital. Reduction, section 66. Share capital can be reduced. Okay, present shareholders can be repaid, or there are provided some procedures by which share capital can be reduced, but it is important that only by following the prescribed process share capital can be reduced. Section 66 needs to be considered. And next alteration is through buyback of shares under section 68. Buyback of shares under section 68. So share capital can be altered by buyback of shares, means company buys its shares back from the shareholders of the company. Power of limited company to alter its share capital. Now, section 61 gives power to a limited company to alter its share capital. A limited company with a share capital can alter the capital clause of its memorandum of association. So we earlier discussed that memorandum has 5 clauses, and one of them is liability clause or capital clause. So this can be altered by a limited company as per section 61. Limited company with a share capital can alter the capital clause provided authority to alter is given in the articles of association in the following ways. Okay, it can alter in the following ways provided the power to alter authorized capital is given in the articles of association of the company. Now, how share capital can be altered? It can be altered by increasing its authorized capital. So, authorized capital is the maximum limit up to which shares can be allotted, and that can be altered or it can be increased. Authorized capital can be increased by applying to ROC by paying further stamp duty. And then, or another way of altering share capital is by consolidating or dividing the whole or any part of its share capital into shares of larger amount. So there is change in the number of shares and face value of shares. So face value can be means Suppose earlier you had 1000 shares of say rupees 10. So now what we are doing is that we are consolidating. Okay, these shares are consolidated into 100 shares of rupees 100 each. Okay, so by consolidating and dividing the whole or any part of its share capital into shares of larger amount. Okay, so amount, shares of larger amount, per face value per share has increased from 10 to 100. This is for example, so this is a way. Then by converting all or any of its fully paid up shares into stock, or vice versa into any denominations. Practically I have not seen this happen, maybe it's a historical way of doing things. So shares can be converted into, only fully paid shares can be converted into stock, and then stock can be reconverted to shares. Then by subdividing the whole or any part of its share capital into shares of smaller amount, exactly opposite this was the case, and we go to this scenario, then we are talking about this. And if we are going from here to here, then we are talking about this. So that was consolidation. This is subdividing the whole or any part of its share capital into shares of smaller amount by cancelling those shares which have not been taken up and reduce its capital accordingly. So we can cancel those shares which have not been taken up, means shares were offered, they are not taken, and then we reduce its capital accordingly. Okay, so these are the ways in which share capital can be altered. Now proceeding further, we have further issue of shares. That is, we can issue shares in a way of rights issue, means we are issuing shares to the present shareholders of the company, or we can issue by way of preferential allotment under section 62. In preferential allotment, we are making allotment to the identified group of persons. Those who are identified, their names are placed before board and they are made offer to subscribe to the shares of the company. A rights issue involves preemptive subscription rights. Okay, here we have preemptive subscription rights to buy additional securities in the company offered to the company's existing security holders. So existing security holders have a preemptive subscription rights to buy additional securities of the company. Issue of further shares. Further shares can be issued to whom? Can be issued to existing equity shareholders. When it is issued to existing equity shareholders, then it is termed as rights issue under section 62 subsection 1 subsection A. So how rights issue is made? By passing a special resolution plus offer through notice. Then offer is made through notice that they can either accept or resign in favor of some other person. Number two way of issue of further shares is to the employees through employee stock option schemes under section 62 subsection 1 subsection B. Here we require a special resolution. Then further shares can be issued to any person for cash or non-cash considerations under section 62 subsection 1 subsection C. Here also special resolution is required. So further shares can be issued to existing shareholders, to employees of the companies, to anybody else for cash or other than cash considerations. Notice shall be dispatched to all the existing shareholders at least 3 days before the opening of the issue. Notice shall be dispatched to all the existing shareholders at least 3 days before the opening of the issue. So if issue is opening after 3 days, then we have to ensure that notice is sent now. In case of a private company, shorter notice less than 3 days shall be served on 90% consent of the members in writing or in electronic mode, means through email. If you get consent of at least 90% of the members, then you can give a shorter notice, and this option is available to only private companies. Okay, so we will pass a special resolution, then we will offer through notice with at least 3 days time period. Issue of bonus shares. Section 63. Now, bonus shares may be issued from free reserves. Number one option we can check is free reserves. Number two option we can check is securities premium reserve. Number three option which we can check is capital redemption reserve. So for issuing bonus shares, we have to check whether we can issue it from, whether we have sufficient free reserves which can be converted to bonus shares, whether we have sufficient securities premium reserve which can be converted into bonus shares. Number three, whether we have sufficient capital redemption reserve which can be converted into bonus shares. Suppose we have all three, then also based on our other available securities and other conditions, which one we should utilize, that thing has also to be considered. Means you have free reserves, you have securities premium reserve, you have capital redemption reserve, still you have to apply mind which amount should be utilized. You cannot just randomly pick any. So there, means these amounts can be available for certain, like free reserves are widely available for many purposes, but securities premium can be utilized only for 2 3 purposes. Similarly, capital redemption reserve can also be utilized only for 1 or 2 purposes. So accordingly, depending on our overall financial statement, we should figure out which reserves should be utilized first for the purpose of issue of bonus shares, in case we have all three, in case we have all three sufficient. Bonus shares shall not be issued from revaluation reserves. So bonus shares shall not be issued from revaluation reserves. Bonus shares shall not be issued from revaluation reserve. Revaluation reserve. What is revaluation reserve? Revaluation reserves is when the assets are revalued. There is no actual change, only their valuation has been figured out, and accordingly the changes are made in the financial statement. Company may capitalize its profits or reserves. Company may capitalize its profits or reserve for the purpose of issuing fully paid up bonus shares. Bonus shares are issued always fully paid up in compliance with following conditions. So these conditions need to be ensured before we are going with a bonus issue. Number one, authorization in the articles of association of the company. Articles must specifically authorize a company to issue bonus shares on the recommendation of board. Board has to recommend, been authorized in the general meeting of the company. Means shareholders are authorizing, but recommendation is made by board of directors of the company. Number three is not defaulted in payment of interest or principal in respect of fixed deposits or debt securities issued by the company. The company should not be in default as to payment of interest or principal in respect of public deposits, in respect of any debt securities issued by the company. So there should be no default in payments. Then number fourth is no default in payment of statutory dues of the employees. Means salaries are paid on time, there is no default. Even if salaries are late or if there is default in payment of salary, then also bonus shares cannot be issued. Number fifth is outstanding partly paid shares, if any, on the date of allotment are made fully paid up. In case there are partly paid up shares, partly paid up means face value is rupees 10. However, the money received on first call, second call is say rupees 6. Then rupees 4 are yet to be called and received by the company. So in case of partly paid shares, a bonus issue cannot be done. First, we have to ensure that shares are fully paid up, complete face value amount is received, and only then we can issue bonus shares. And then condition is complies with the rule 14 of the company share capital and debenture rules 2014, that a company which has once announced the decision of the board recommending the board bonus issue shall not subsequently withdraw the same. So Rule 14 requires that if a company has announced that it will bring a bonus issue, okay, means once the board of directors have passed a resolution or decided that bonus issue is to made, then it cannot go back. Then it cannot withdraw the same. Moving further, reduction of share capital. Our next topic is reduction of share capital, section 66. Maintenance of capital is one of the main principles of company law because any reduction of capital diminishes the fund out of which creditors and other debt holders are to be paid. So even if the company goes into winding up, still creditors will be paid based on its present paid up capital. So if present paid up capital is reduced, then we have to ensure that creditors and debt holders interest is taken care of. So maintenance of capital is one of the main principles of the company law because any reduction of capital diminishes the funds out of which creditors and other debt holders are to be paid. Therefore, adversely impact them. Therefore, it can adversely impact them. But sometimes it may become necessary for the company to bring about a reduction in its share capital. So only when it is necessary then this step be taken. Company being company limited by shares or company limited by guarantee and having a share capital may reduce the share capital in the following manner. So company being company limited by shares or company limited by guarantee but having a share capital may reduce share capital in the following manner. Existing extinguish or reduce the liability on its shares in respect of the share capital not paid up. So certain portion of share capital is not paid up and we extinguish or reduce that liability that you do not need to pay it further. This is also reduction in share capital. Second is cancel any paid up share capital which is lost or is unrepresented by any available assets. So we are cancelling any paid up capital which is lost or which is unrepresentative of any available assets. Means the share capital is lost. There are no assets to match the share capital. Okay, then also share capital can be reduced from the books of the company, balance sheet of the company. Pay off any paid up share capital which is in excess of the wants of the company. So if the company has any paid up capital which is in excess of the wants of the company, it do not require that the funds are surplus, then it can choose to pay it off, give it back to the shareholders. Now, subject to passing of special resolution. Now this paying off requires a special resolution is passed before the paid up capital, excess paid up capital is paid with. Number two, alter its memorandum by reducing the amount of its share capital and of its shares accordingly. It will reduce amount of share capital and number of shares accordingly. Alter the memorandum. Repayment of any deposits accepted. If the company has any deposits, then it will repay them either before or after commencement of this act, the interest payable thereof. So this is subject to special resolution, alteration of memorandum and repayment of deposits. Means if deposits are there, then deposits needs to be repaid. Capital cannot be paid back without paying off deposits. If the company has accepted public deposits, it has to alter its a memorandum of association and it has to file a special resolution. Now, moving back to the case of extinguishing or reducing, first one, on its share capital in respect of share capital not paid up. So here the condition is issue of notice by the tribunal. Either a tribunal has issued notice to do so, then if the tribunal has issued notice to do so, the tribunal may make an order confirming the reduction of share capital on such terms and conditions as it deems fit. So if the tribunal has issued notice for reduction of share capital, then its terms and conditions needs to be complied with. Number two is if you are extinguishing partly paid shares, then you require central government power delegated to RD. You require approval of central government, and the power is delegated to regional director. Means for getting approval of central government, you need to apply to regional director. Then you have to apply to registrar of companies and securities and exchange board in case of listed company, and the creditors of the company. These all shall consider the representations, if any, made by them within 3 months from the date of receipt of the notice. So you will file your intention notice of reducing share capital to central government, means RD, registrar of companies, SEBI in case of listed company, and the creditors of the company. This is important. And whatever representation they have made, that needs to be considered within 3 months, means they have 3 months time to make a representation back to the company. Okay, now next topic is restriction on purchase of by company or giving of loan by it for purchase of its own shares. Section 67. So company cannot purchase its own shares. Company cannot give loan to someone to purchase its shares. So company can neither purchase directly its own shares nor it can give loan to purchase its own shares. This is provided in section 67. A company cannot buy its own shares because reduction of capital results in diminishing the funds out of which creditors are to be paid, hence adversely affect the creditors. However, this restriction is not absolute. So there is primary restriction that it cannot purchase its shares because by paying money it will reduce funds available to pay off the creditors. Reduction according to the applicable provisions. How reduction is allowed? Company limited by shares or company by guarantee having a share capital shall not buy its own shares unless the consequent reduction of share capital is affected under the provisions of the Act. So a limited company shall not buy its own shares unless the consequent reduction of share capital is affected under the provisions of the Act. Means you can do this only in compliance with the process provided in the Act. Restriction on giving loan, guarantee or provision of security, etc. Public companies shall not give any financial assistance, whether directly or indirectly, and whether by means of a loan, guarantee or the provision of security or otherwise. So company cannot give loan, okay, it cannot give any financial assistance. And which company are we talking about? Public company, not a private company. Public company cannot give any loan or financial assistance, whether directly or indirectly, and whether by means of a loan, guarantee or provision of security or otherwise. Howsoever it will not get someone to buy the securities of the company for the purpose of or in connection with purchase or subscription made or to be made by any person of or for any shares in the company or in the holding company. So not for purchase of its own shares, not for purchase of shares of its holding company. A public company will not give. A public company will not give. A public company will not give money, security, enticement, or anything. What are the exceptions? Exceptions are: company may provide financial assistance in the following cases. Number one, lending of money by a banking company in the ordinary course of its business. A banking company in the ordinary course of business is lending money, then it is allowed. The provision of money for the purchase of fully paid shares in the company or its holding company by trustees for and on behalf of company's employees in accordance with the employee share scheme approved by company through special resolution as per Rule 16 of the company's share capital and debenture rules 2014. So first was lending by a banking company is exempt in the ordinary course of business. Second one is that provision of money for the purchase of fully paid up shares of company or its holding company by trustees. So trustees are holding shares on behalf of employees under the scheme of employee stock option scheme. So under any employee share scheme, if a trustee is holding shares on behalf of employees, then indirectly it is amounting. Okay, then this is allowed. Number three is lending money by a company to its employees for not exceeding 6 months' salary of the employee to enable them to buy or subscribe fully paid shares in the company or its holding company and to hold them by way of beneficial ownership. So companies lending money to the employees up to a maximum limit of 6 months of their salary to enable them to buy or subscribe fully paid shares of the company or its holding company and to hold them by way of beneficial ownership. They are holding by way of beneficial ownership. What is the meaning of beneficial ownership? Means they are holding for their own benefit. They are not holding on behalf of company. It is not that company has given employees money so that employees can purchase shares on behalf of company. Indirectly company is owing shares, so beneficial interest remains with the employees and the company can pay them money up to rupees 6 up to their 6 months of salary. So these are the exceptions. Banking company is an exception. Trustee holding shares on behalf of employees, exception. Lending money uh, to the employees up to 6 months of their salary for holding shares in beneficial capacity. Non-applicability of section 67. When is section 67? What is section 67? Restriction on purchase by company or giving of loan. So one is this section not applicable. Private company, if not defaulted in filing its financial statement under section 137 and annual return under section 92, in whose case all the following three conditions fulfilled. Okay, private company which is not in default of its annual filing is exempted if it fulfills the following three conditions, mandatory conditions. Number one is in whose share capital no other body corporate has invested any money. So means there is no other body corporate in its share capital, neither one share nor any. Okay, neither one share nor any. There should be no body corporate in the shareholding pattern. All the shareholders must be individuals. So there is no body corporate in the shareholding pattern. Number two requirement is if the borrowings of such a company from the banks or financial institutions or any body corporate is less than twice its paid up capital or 50 crore rupees, whichever is lower. So borrowings of the company either from banks, financial institutions or body corporate, howsoever there are borrowings, maybe from any other body corporate, then those are less than twice the, okay, is less than twice the paid up share capital. Maybe paid up share capital is 1 lakh, then it can be less than 2 lakhs or 50 crore rupees, whichever is lower. So in our example, 1 lakh is lower, then double 1 lakh is 2 lakh. Up to 2 lakh it can borrow from banks and still exercise this power. But if suppose this increases beyond 50 crores, then 50 crore becomes the lower limit. Okay. Last third C is such a company is not in default in repayment of such borrowing subsisting at the time of making transaction under this section. So there is no default in repayment of such borrowings. So borrowings not more than twice, there is no default in repayment, and company do not have a shareholder which is a body corporate. Nidhi companies. Now this section 67, that company cannot buy its own shares or finance buying of its own shares, is not applicable to Nidhi companies, means mutual benefit companies. When shares are purchased by the company from a member on his ceasing to be a depositor or borrower shall not be considered as reduction under section 66. So when shares are purchased from a member on his ceasing to be a depositor or borrower, then also this is not applicable. So if a member is ceasing to be a member of a Nidhi company, mutual benefit company, then if the shares are purchased by the company, then it is allowed for Nidhi company. In case of private company, borrowings not more than twice or 50 crores, whichever is lower, and there is no default in borrowings. Plus, there are no body corporates in the shareholders of the company. So then, private companies, Nidhi companies, and usually section 67 is for public companies. Okay. So next time we will move further with power of the company to purchase its own shares, section 68. This we will cover in next video. I hope this video was of value to you. Thank you.